Just on the empathy question, you know, I may be the only person in this city who thinks this, maybe the only one in the country, but I don't know why we're so defensive about the fact that the president would want someone on the Supreme Court who, or on any court, who has empathy. The fact is that corporations, businesses, whether it's in an employment litigation setting or labor setting or in corporation versus corporation, ask judges for empathy. They want a judge who understands business and what they perceive its business needs are. In the ADA world, you know, you have the issue of whether an employer can reasonably accommodate a disability. Well, when an employer raises that defense, he's asking, or it's asking the judge to understand its needs, to be sympathetic, to be empathetic. We see it in Title VII when an employer raises a defense of bona fide occupational qualification and why it needs a man as opposed to a woman. It's sympathy. When a prisoner throws himself on the mercy of the court, it's empathy. When you go before the country judge, you want that judge to understand what you're about. It's empathy. So I really don't understand it, why we're so defensive.
Yeah, I mean, if you want to read a Supreme Court opinion that demonstrates empathy, I mean, one that I would cite, it's a remarkable opinion, in many ways a moving one. Last term, the Supreme Court decided a case called Kennedy versus Louisiana, which was about whether the Eighth Amendment allowed for the death penalty for people convicted of raping children. Justice Alito's dissent in this case contains a few remarkable paragraphs about the impact of rape on these children, about the lifetime scars that they bear, the trauma that they bear, their lessened outcomes in life as a result of being raped, and how that should factor into whether the death penalty as a punishment should be considered cruel and unusual. I mean, it is, you know, if you want to look at empathy, I mean, he understands, you know, what happens to these kids. And he wasn't afraid to use that as a persuasive tool in writing his opinion. We shouldn't be afraid of having empathy on our side either.
So this is great. This panel's really prescient because we were going to go into a section about what's the right saying and how to respond to it. So let's stay on empathy for one more minute, and then I want to move to some other issues. But did you have something to say on the empathy point?
Well, not on the empathy. It is sort of the empathy. It's this whole, her famous Berkeley speech.
That was going to be my next question.
Right. I told you.
This is amazing.
There you go. I think it's interesting that comment that I won't repeat it because we've all heard it a million times, was in response to a comment by Sandra Day O'Connor about, you know, that wise man, wise woman will reach the same, you know. And I think what you see in Sotomayor and maybe her peers age-wise, generation, you know, products of the civil rights movement, is an understanding. I don't think she's going to come at things from a formal equality point of view. I think the fact that I was struck by all the articles about her when she was at Princeton, you know, her activism to bring more Latino faculty on board and more Latino students into the school, and then when she had her experience with the law firm at Yale, that she actually filed a complaint about the comments about her. She is of a different generation than Sandra Day O'Connor. Does not believe she has to fit into the male world in order to be a successful professional jurist. And I think that means for her that I'm very hopeful that because of that, not only will she bring a perspective to the court that is like that, I think she's going to actually be very adamant about those issues on the court. I would have been interesting to see her on the court on a Ledbetter case, you know, and see how she would have handled that. I think it would have been interesting to see her during the school desegregation case. Not because maybe she does replace Souter, but personalities and experiences do matter on the court. And I don't think she just has empathy. I think that she has extremely strong feelings about equality. And I think that's where we're going to see her dig in her heels.
So we've kind of covered the rights claim that she's a racist, and we've covered the rights claim that that somehow she's empathetic and shouldn't be empathetic unless it's okay to be. Say a few more words, Dahlia, about the activist. To help people, you made a very strong point that she's not an activist. Can you explain what that's all about?
Well, I mean, first of all, the word activist means nothing, right? And we all know that it means whatever the Rorschach test that's in front of you, you don't like this particular case, it must be an activist court. And every attempt to study empirically what judicial activism means, gets hung up at the first gate because, if it means striking down legislation, well, we've heard already, the most activist court in history was the Rehnquist court. If it means, not deferring to state legislatures, well, again, if it means not adhering to precedent, my God, Clarence Thomas says he doesn't even believe in precedent. So, every time you hear the word activist, you should be like my 3-year-old and put your hands on your ears and just go, it's not true. It doesn't mean anything. And we need to just excise that word from our vocabulary. But I think, one of the things that's very interesting is that the case that is supposed to be a proxy for everything that's wrong with Sotomayor is this Ricci case, right? This New Haven firefighters case. And time and again, you hear liberals wringing their hands saying, oh my God, how are we going to get out of this mess? This is horrible for her. Well, bracket the fact that probably the 3-judge panel shouldn't have handled it in, a paragraph. It was handled badly. But I think progressives need to very proudly say, there's a statute. It's a very popular statute. The statute told the city of New Haven to do what the city of New Haven did. So the city of New Haven was not activist. The district court that said the city of New Haven did what the statute compelled them to do was also not activist. And the 3-judge panel that went so far as to say, poor Frank Ricci, we feel bad for him, but we can't change the statute or overrule the district court, was also not activist. So when the Supreme Court strikes down the statute and when they overrule Ricci, then we should all take our hands off our ears and yell, activists, because that will be the first piece of activism we see in this chain. And what is crazy-making about this case is that progressives need to just say that over and over again. She didn't reach beyond the result in front of her. She didn't reach beyond the statute in front of her. She did exactly what John Roberts at his humble best would have done. So I think progressives need to get out of this defensive crouch about Ricci and say, this is exactly what we presumably want judges to